Yes.
Okay, sorry, I wasn't hearing you guys. Okay, we're good. Sorry, I'm late.
Oh,
Apologize.
no problem. So, I mean, I was just saying we're ready to start. So whenever you're ready, we can call the meeting to order and do roll call vote.
Sounds good.
Okay. Are
I'm
you
ready.
ready? Should I?
Yeah.
Okay. Vicky, would you mind doing the housekeeping, and then I'll move into roll call?
Sure, no problem. Everyone can hear me okay?
Yes.
Okay. Welcome committee members, liaisons, and members of the public to the Subcommittee of the Legal Services Trust Fund Commission. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for those joining this public meeting, whether by phone or Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. All Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. And a friendly reminder that this is a video conference and to please be aware of your surroundings behind you. If you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid any audio feedback issues. And lastly, while joining, audio via computer is highly recommended. If an individual loses audio, they can call in separately using the Zoom conference link. Excuse me, Zoom conference number.
Thank you, Vicky. So I'll do a roll call vote right now. Amin Al-Sarraf.
Present.
Catherine Blakemore.
Present.
Jim Meeker.
Here.
I'll do liaisons. Selena Copeland.
Present.
Bonnie Huff. Christine Gonan. Okay. State Bar staff. Chris McConkey.
Here.
Erica Carroll.
Here.
Andrea Fatanides.
Here.
Brady Dewar.
Here.
Vicky Avila.
Here.
Are there any other State Bar staff or liaisons that I've missed? Are there members of the public who would like to introduce yourself?
I'm going to allow you to talk.
Yeah, can you unmute and if people want to introduce themselves? You're not required to introduce yourself, but you're welcome to introduce yourself.
Lauren Klein from LAC is here.
Hi, Lauren.
Hi.
Zach Newman from LAC is also here.
Hi, Zach.
And William's here as well.
Oh, hi, William. Welcome. Are there any other members of the public that would like to introduce yourself?
Those are the only three.
Okay. And are there any members of the public who would like to make a public comment at this point? No? Okay, great. So Amin, would it be okay to move into the substantive portion of our agenda today?
Yes.
Okay,
Yes,
great.
please do.
So we only have two agenda items today. The first one, as you know, is that we'll be sharing the results of the IELTA survey and then discussing that. And then related to that, a second agenda item would be this working group will make a recommendation of how to proceed given the results. So I just wanted to quickly kind of remind everybody, the staff has prepared a PowerPoint presentation summarizing the data, and we apologize that there's no materials in advance. We've been literally working up until last night to clarify some of the results of the survey and to reach out to programs, so we could not package it in time to have official meeting materials. But the PowerPoint is available and will be available to any members of the public who chooses to have access to it after the meeting. So just want to, again, remind everybody of where we're at. The commission met on December 15th last year to review how to proceed with whether to support a change to the IELTA statute, specifically around increasing the client eligibility from 125% to some other threshold. That memo and the presentation that staff provided, you know, as representative of the Rules Committee, laid out some options going perhaps 200% or AMI. Related to that is the question of, if we were to increase the client eligibility income threshold, should we increase and change the funding formula so the two pieces run in tandem with one another? As you'll recall, right now, the existing statute and policy is that client eligibility is at 125% of the federal poverty threshold, and the funding formula follows at 125% in how we divide up the ward allocation. So those were the two questions that are on the table. State Bar staff, as well as the Rules Committee, in conjunction with our Office of Research and Accountability, the last few months, we've been taking a deeper dive, doing more analysis in terms of the impact if we were to select all the various options to see how that would impact programs, how many more clients would become eligible in California, how the funding would change if we were to opt into kind of the different various scenarios. The preliminary recommendation that was made to the Trust Fund Commission from the Rules Committee in December was to increase the threshold from 125% to 200%, given that our threshold right now is pretty out of date, and most funders are already at the 200% level at least. We recommend not going so high as AMI, just because funding is low right now, IALTA funding, and opening up to AMI, though those clients would be are deserving, would perhaps dilute the funding a bit too much in a period that there's some uncertainty. So the recommendation would be to move up to 200% for client eligibility, but because of all the analysis that State Bar staff has done in terms of the funding formula, we recommend leaving the funding formula at 125%, because from our analysis, it showed that if we moved it up to 200%, there might be some shifts, though small right now, from moving some funding out of rural areas and some high impoverished areas of California. So we believe that risk is a little bit too risky, given where the climate right now in the political environment. So we think that the safer, more conservative move is to move client eligibility up to 200%, however, keep funding formula at status quo. We wanted to share this analysis with the legal aid community, our grantees, to make sure that they understood the analysis and the implications if we were to move forward. Selena had informally reached out to them prior to that December 15th meeting, several times leading up to several Rules Committee meeting, and there appeared to be consensus around the 200%. However, we thought it was prudent to get kind of an official stance from them through a survey. And then I don't think it was on their forefront to think about the funding formula. So we also wanted to explain why we should move up or why we shouldn't move it up. So following that December 15th meeting, on December 17th, the State Bar staff held an hour-and-a-half webinar to kind of go through all the options and the implications, and share with them what the preliminary staff recommendation was, and also kind of timeline that this working group would be meeting again. We had a very high attendance that rate. I can't remember exactly how many organizations and programs, but I want to say about between 100 and 150 participants across 70 organizations. So very, very high response rate. People are very interested in this topic. We released the survey on December 18th, and it was due January 6th, so due last Wednesday. In that period, LAC also convened a number of meetings to further answer questions from the community. It's a really expedited process, and we know it was being done over the holidays. So State Bar staff and LAC staff have made themselves available pretty much nonstop between the period. We got back the results last week. As we anticipated, the client eligibility piece, where people seemed there was more clarity around what the issue was, the response, and we're going to go through and share the response in a bit. I'm just giving a preview now. There seemed to be a consensus. The funding formula piece, the responses, the initial responses was all over the place. So State Bar staff and LAC did confer, and it seemed like there was a lot of questions coming out from Selena's meeting as well as our meeting about the funding formula. And I think conceptually people had a hard time understanding it because the client eligibility piece was the piece that they had come to LAC, and LAC had come to the State Bar to the commission to request a change. But the funding formula is always a little bit more a technical piece for programs to understand. So what we did, because there seemed to be a split, is State Bar staff as well as LAC staff reached out to those programs that seem to vote to change the formula to make sure, first, is that an accurate vote, and secondly, is that the vote that they in fact wanted to do. So based on kind of that feedback, there were a lot of people that changed their votes. They just didn't understand the question, and then LAC came in and did a bit more clarification. So that's why the reason why we couldn't run you a report right after Wednesday's when the survey closed last Wednesday, because there was still a lot of back and forth between grantees and LAC and us leading up until yesterday when I sent out the email. So that's kind of the long story. And now we can just move right in and share kind of the data. So bear with me. And since, it's really informal, Ruth, just stop me when you have questions.
So I just want to refresh my memory about one thing. The Trust Fund Commission in December, I know we had a discussion about the two components of the proposed change. Did we take a position, did the Trust Fund Commission itself take a position on the funding formula piece? No.
Well, the staff took a position on that. The recommendation is, and there was a preliminary recommendation because we really wanted to wait to hear from the community to see if there was something that we were missing. But our preliminary recommendation based on our analysis was to not change the funding formula.
Yeah, I just remember this very long discussion
Yes.
in that meeting, and I was trying to recollect whether the commission had taken.
No.
No.
The commission didn't take a stance on either. And in fact, that's why this subcommittee was.
Yeah, I got all that. I just was trying to focus on the second question where I feel like the commission generally supported the recommendation not to change the county, I'll just call it the county distribution piece, right? So,
yeah. So my impression that was leaning as well, but we didn't have, there wasn't a vote and it wasn't formalized. But my leaning from like the tone of the conversation was that at least the commission members that were engaged in the discussion, that they did support preliminarily staff's recommendation of no funding, no change to the funding formula.
Yeah, my recollection of that discussion too was that the analysis tend to show that there was some shifting of money to the larger urban counties away from the smaller rural counties.
Mm-hmm.
I know for me, that would be a concern.
Yeah.
The other question I have, Dawn, from that webinar, because I attended that.
Yes.
One person raised, I thought, a very good issue, and I want to know if you guys have run the numbers on that, on what the impact on the federal poverty level guidelines will be when the minimum wage is raised to $15. I mean,
yeah, there was somebody that asked that question. I can't recall the name of the program, and I know Selena has been in conversation about that, but we didn't have the bandwidth to run to see the impact on minimum wage. I mean, I imagine it's just gonna make the situation more dire if minimum wage is raised, but that's just my personal theory. I know Selena, I know you and I had some back and forth around that piece, and that I think was the same program that raised the concern to you again separately.
Yeah, I mean, Erica may know the numbers better off the top of her head, but my recollection is that once the minimum wage is raised, which it's raised in California effective January 1st, I think to $14 an hour. Mm-hmm. It essentially, even now, if you're a household of 4 and you have one wage earner who's making a minimum wage job, they really are at the threshold where it kind of depends on how many hours per week they're working, whether or not they qualify for legal aid. Mm-hmm. And we heard that from a lot of folks who were saying with their clients who may have variable sources of income, it was just really hard because, if a client has a good week, and I heard stories of like, what if my client sells more tamales this week? Then they wouldn't qualify for services, but over the totality of the year, they're clearly they were low income.
Yeah, so we don't have like hard analysis for you, Jim, but it's just like based on the fact that minimum wage is going to go up, that I think that would support raising the client eligibility to give more flexibility in accepting clients on like a philosophical level. But we don't have like we didn't run an analysis, and I think we would have a hard time running that. We would need a lot more time to be able to do that type of analysis.
And just real quickly, I wanted to let the other committee members know about LAC's process on this. As Dwan mentioned, our community has been talking about increasing the income threshold for a long time because tying it to the federal poverty threshold of 125% has always felt out of step for California because our cost of living and everything else is so much more expensive, and our minimum wage is much higher than the federal minimum wage. And so we've had a number of conversations just over the years about when can we do it, how can we do it where, where we hopefully haven't asked for more funding and we're not worried about, millions more people being eligible for funding. But everyone in the course of several phone calls we held agreed that now is the time. And a lot of executive directors shared stories where they said that they are feeling the pressure from their community where people impacted by COVID are at risk of eviction, and they're having to tell people now that they don't qualify for legal aid. And it's, it could erode trust in the community when people think they should qualify for legal aid, don't. And so I think this is kind of I would urge the committee to support what the community wants to do because, everyone really agreed that now is the time. And I think that I want to just own up to the fact that a lot of the confusion around the county distribution is due to LACs not focusing on it enough in our calls. We didn't have a clear recommendation going out because we, like the state bar, were in a information receive mode. We wanted to hear from the community what they wanted before we had a strong position. I personally, like Jim, had real reservations about any risk of moving rural funding to urban areas. But we waited until we heard from community members before we came out with LAC's strong recommendation. And so I think if we had come out with a much stronger recommendation earlier, it would be less all over the board, as Dwan said. But we wanted to hear from folks first. But now it's really clear. I think that, the fact that EAF dollars flow like IOLTA dollars, the risk of moving a lot of funds from rural communities to urban communities with a distribution change feels just not worth it now it's just a real challenge to take money from rural communities now when there's already a rural funding gap.
And it is less all over the board. And I think that was like when we had a chance to speak to the programs that were either unsure or voted a certain way, and we explained, it was like, oh yeah, of course we want to vote for no change. So that has taken a lot of time. So why don't we just, I guess, dig into it if it's okay. I mean, is it okay if I proceed?
Yeah, although it looks like Catherine has a comment.
Oh yes, of course, Catherine.
I just feel like Dwan and Selena have a lot of information and I have none. And so we can just kind of go through it a little more measured rather than I'm just honestly having a little bit of a hard time keeping up, which is why I keep asking questions.
No, and that's good. And this is part of, just to be completely honest with you, Catherine, it's a lot of information to provide to grantees the week before Christmas. So that's why the funding formula piece was a little bit harder for them to conceptualize, whereas the time eligibility was easier to digest. And that's what we're running into. I mean, a lot of this is a timing issue. Obviously, we would love to have another 3 months to really walk people through very, 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 step by step. It's just we're hitting a kind of a timing issue with the legislative cycle. And so we apologize for that. It feels more rushed than it should.
I'm not criticizing the timeline. I'm just asking in the discussion that I don't have anything. I'm being asked to look at things on a very small screen, and it's just going to take a little while to make sure I understand it. That's really all I'm asking.
Of course. And I do tend to talk fast, so please stop me. And we're a small group, so this is where I'm going to show you my presentation, but I hope it's just a dialogue really between all of us.
Great.
Okay. So hold on, bear with me. Bring up my. Okay, great. Can you see this now?
Mm-hmm.
Okay, I'm just going to get to the heart of it. So we sent the survey out to 100 grantees. There are 100 existing 2021 grantees. Of the 100, 82 responded, which we think is a really strong response rate. I mean, obviously, we would have loved it to be 100% response rate, but 82 is really strong. And there's a slide on the next page, Jim, because I know you have some questions on who didn't respond to share with you. there was one program that affirmatively abstained, and Uncommon Law is a new grantee. So I'm not really sure why they abstained. Chris might have a little bit more insight to this, but it might just be because they're so new. Then we have another 17 non-responders, 10 QSPs, and 7 support centers. And I do want to kind of underscore the 7 support centers. You know, this issue, obviously the support centers are part of the our IALTA community, but it does impact support centers a little bit less. I mean, it does impact them less. It's not direct because support centers, unlike QSPs, they don't provide the direct services to clients. As you'll recall, the Qualified Legal Services projects are what you think of a typical legal aid program where a client comes to the door and they received legal aid help. Support centers provide the sort of support services to our QSP community in the form of various types of technical assistance. So it doesn't really impact them directly. There are occasions where support centers do provide direct services in the form of co-counseling impact cases, but in those instances, the client threshold isn't really, doesn't impact them as much. Usually that's in conjunction with the QSP. So, you know, that we've heard from several support centers anecdotally over the phone that, you know, they didn't vote because they really are just deferring to their QSP's partner because it's really a QSP issue. Chris, I don't know, and Chris in our office and Erica did a lot of the reaching out directly to programs. I don't know if you have anything else to add regarding the support center piece.
No, Dwan, that was a perfect summary of what I heard from multiple support centers. They kind of expressed like a academic perspective on, you know, yes to increasing the threshold for eligibility, and then wanted their QLSP peers to have the greatest say in the funding distribution.
Yeah, so I think the more important is perhaps the 10 QSPs that didn't respond rather than thinking about it as 17 non-responders, because the support centers didn't take a position, maybe because of that. So here's a list of the non-respondents. We try to pull out the support centers so you can see. And I did share with you, I think last night, that some of these programs, when we looked at them one by one that didn't respond, some of them were smaller programs that we've seen that don't have a track record of responding to us. So that could explain perhaps the non-responsiveness. And some of them, anecdotally speaking, haven't been as engaged, even if they are not of a smaller program. They don't always respond to our surveys. Sometimes they turn in things late. So this list isn't really an anomaly to us in terms of who didn't respond, but there were 2 programs, and I think I highlighted them last night in my email to you. Greater Bakersfield's Legal Assistance and LACBA, where are they? LACBA number 6 and number 11. And the reason I wanted to pull that and highlight that for you, because GBLA is an LST funded program, so they are a larger program. So it would have been more ideal if they funded. And also, you know, LACBA does provide services, and they have been vocal on certain things, and they didn't respond. So that we were curious about that. Chris did leave them several messages. Selena, do you know, or Zach, do you know anything more about why they didn't respond?
I could have sworn that Estella was on a meeting that we had where we discussed this and she was in support. I wonder if it was just, I don't know if Chris or Zach had heard anything else back from them, but I thought I heard her say at least that she supported it in a separate meeting. So there's just not a record of it.
Yeah, and there might be, but we did try to follow up because it would be nice that all the LSC programs and all the field programs, and like I said, LACBA, we know usually they're really engaged in process like this. So I mean, you know, and Chris did try to reach out not just to those 2, but to everybody on this list to see if they can respond. And Chris, can you kind of walk us through like kind of the process, and maybe Selena, you can share also your outreach.
Yeah, so you know, I started reaching out to some of the non-respondents and others who did respond, but about whose responses we had questions on Friday afternoon. So we sent a few emails, spoke with a lot of organizations on Friday, and then on Monday I made a special outreach attempt for GBLA and LACBA. Sent them a couple of emails and called. And they haven't responded since. So I don't know if it's just a particularly busy time for them. I think that they probably would be interested in the outcome of this issue, but maybe something about the timing just didn't work out for them.
But I do want to pause, since we did not receive 100% response rate, to see, I guess, as a first question, does that 82% seem like a strong number? The staff opinion, it's a very strong response rate, given that, you know, we have 100 grantees, that it would be almost very, very hard to get 100% response rate.
A clarifying question, is Bakersfield the only LSC funded program that did not respond?
Yes.
And in terms of when you say smaller programs, you're defining small as how much money we give them or how many?
No, I didn't.
clients that's
I eyeballed it, and when I went through for each one of these, I thought either, again, this is just like me, either they had like a history of not being that engaged in issues, state bar related issues and topics when we send out, or they are on the smaller, like for instance, number 5, family legal assistance chalk. I mean, their staff of like 3. You know, a center for a gender and refugee right there, though they're a support center, they're also staff of like 4 or 5. So there's some senior programs here, small staff, but I didn't like have a threshold. So it wasn't
Okay.
an academic, I guess, when I made that statement.
So size, small size means small staff. Okay.
Yeah.
I think it's a mix of, it's Catherine on this. I mean, some of them, I don't view the Inner City Law Center as a small program.
Mhm.
And they didn't respond.
Yeah.
So I don't actually, and I don't know Alameda County Homeless Action Center and that. So I just think it's a list of non-respondents, and maybe some didn't respond because they're small, or I think it's hard to speculate why people didn't respond, and they're not all small programs in my
Yeah.
view.
And I guess I meant that to me, and I should have clarified that it was either because they were small, or I had a history, my personal history with them or the staff, that they were not as responsive on certain things. And Alameda 1 and 2 is another example of not being as responsive to us on other issues. But sure, maybe the more accurate is just they're non-respondent. We don't know the reason why. We have reached out, and that's a factual statement then.
Yeah, and so what you really have is 90 qualified legal services programs, of which 10 didn't respond. I actually agree with the analysis about support centers. It doesn't really affect their work or the funding they're going to receive, either one of them. And so it's really of the, I guess, from, since you sent it to 100, whatever the, you have to my thinking, almost subtract out the support centers and whatever they thought about it, and just focus on the qualified legal services programs. And I think the response rate for those folks would then be higher than the roughly 80%. Right?
Yeah, I think if we could do quick math,
I don't know. I mean, I'm just looking at this. So there's
Yeah.
7 here, I think, that didn't respond, but there's some number that, yeah, I don't know. I don't know who of the 82, what number of qualified legal services programs there were versus support centers.
Yeah. So that may raise it a couple percentage, but in any case, I think we're still hovering in that, you know, perhaps, you know, 80-ish% for a response rate. So I guess the first question or discussion point is, do you think that's a good response rate? Again, I think that doesn't change staffs if it increases and you know, we think that's a high response rate.
I think if it's an 80% response rate for qualified legal services programs, it's a good response rate, but I can't tell that from that because I don't know what I just don't know who's in the 82. How many qualified legal, how many support centers are there overall?
There are 22 support centers.
Okay, so we know that 7 of them didn't respond, right? Yeah, so
That's correct.
a third didn't respond. So you have, you know, roughly 14 of the 82 roughly are support centers, right? Out of the.
If you wanted to take out just the 22 support centers when we do I mean, I guess Chris or Erica, could you do the quick math right now for Catherine? See what the response rate for just QSPs?
Yeah. So we're going to remove the support centers from both the respondents and like the total list of eligible respondents. So we're like just looking at the QLSPs.
Right.
Okay.
So it's 100 minus 22, right? Which, right?
I'll leave myself
78.
Yeah.
Which is 78.
And
And
then,
go ahead.
oh, sorry.
And then you have to subtract out of the 82.
2 minus 15.
Right.
All right, so 67 out of 78 QLSPs.
Yeah.
And Dwan, I also realized that some of those folks who didn't respond, they started the survey because I recognize that they started. And I wonder if it's just the distribution piece where they stopped and they thought that they didn't want to make a vote on that.
Yeah, we thought about it too, and this is conservative because, like I said, a lot of people, we reached out to a lot of people and they didn't come back to us. So I think with another week or two, we probably could get a higher rate, but we wanted to be conservative and not when we're presenting the data. So we don't want to make.
We have what we have, right? So
Yeah,
isn't
we
that
have what we
like,
have.
isn't it like a, anyway,
86%? I get
86.
86%.
85?
85.9.
Yeah.
Okay. So, are any other comments, discussion point? If not, we just keep moving. Okay, great.
Seems fine to me.
Oh, sorry, Mina, did you say
No, I
something?
was just saying that seems fine to me. I agree.
Great. So now the next few slides is just the response for each question, and then we have a couple slides summarizing them. Erica, can I hand this over to you, this piece, to go over these questions?
Sure. So the initial question, we wanted to get a sense from programs of essentially what percentage of their clients are actually within or above 125% of the federal poverty level. So the initial question was for them to estimate that for us. We have about 34% that are less than 10% of their client population, another 30% between 10 and 25%, and only 15% between 26 and 50. I would imagine we had feedback from a few programs that you know, they would essentially, this was the one question where they would have to engage in, you know, analysis of their own numbers, and some weren't prepared to do that. So I think that's why there's kind of that higher percentage of respondents indicating that they're not sure. But based on what we know from current grantees, all of them would fall within those first three options. We don't have any grantees that are have clients that are above 125%. That's the majority of their client population. So, and then the small percent that would be more than 25% would be very few programs, because that would impact their primary purpose. And those are the kinds of applications that come to the Eligibility and Budget Review Committee every year to analyze their eligibility for funding. So,
would it be logical to assume that most of the support centers are the not sures and don't know?
Yeah, that could also be part of it as well. Yeah.
Yeah. But we also fielded questions from programs that are like, you know, it would take us a lot of time. It's moving into the holidays. We don't have the bandwidth. We're just going to put not sure. Is that okay? Move on to the, you know, the other questions. And we said, yes, that's fine, because it was hard for them. We wanted them to complete the survey rather than get stuck on this question.
Mm-hmm.
So of the 12 that were between 26 and 50, right? LSC currently allows its grantees to serve up to 200%. So I guess I'm guessing that they're going to be highly represented in that group. Do we know that, or?
That's something we could pull out from the individual responses, but that's not something we have sort of immediately available.
Yeah,
we can find out.
We don't have them immediately available. You know, we intended to build this out on Qualtrics, which is what the apparatus that we use for the survey, hoping that we would run a lot of cross analysis. But because we were going back and programs were changing their votes up until yesterday, and some of them, there were a handful that were just they emailed us, but they didn't have the bandwidth to go in and redo it. So we cataloged it. We did a manual count. We're going to go back and clean that up after this meeting. If we were to you know, take this to the legislature to make sure everything is like, you know, all our I's are dotted and all our T's are crossed. But because it's not officially in the Qualtrics survey, we couldn't run all those fancy reports for you, which is why originally we wanted to, because we were told from our Araya team, we already gave them the qualified expenditures from the programs, so they could potentially do more like fancy analysis. It's just we couldn't yesterday.
Yeah, I just think that's unfortunate, but we are where we are. Like, right.
I have the data in front of me, and because if it's one like this where there's only 12 respondents, I can quickly sort and give you a really quick answer. Sometimes it would probably take me a little too long, but I can see for this one, for instance, between 26 and 50, it's among LSC organizations. It's just Legal Aid Society of San Diego, Community Legal Aid SoCal, California Indian Legal Services, and Neighborhood Legal Services of LA County.
So is that three, Chris?
That's 4, 1, 2, 3, 4 of the 12.
My recollection is that the LSC funded programs actually have a pretty high QE percentage. So they may have answered this survey without looking at the data that they're presenting to the bar. Because I think that because the organizations, they prioritize serving the lowest income people, their QEs are actually a pretty high percentage.
Yeah, we ran a report before the holidays to see. I was curious to see what their QE percentage was, just thinking that for LSC programs, it might be anywhere in the 80%. And I have to say, I don't have it in front of me, but their QE percentage was like in the high 90s, like very, very high 90s. So that's they're up to they can serve up to a 200%, but that shows that they're not. Most of their clients are still within the 125. And I do think that this is going to hold out if we go to change, that it's going to give programs flexibility, but they're not going to rush to then only serve clients at the 200% range. The majority is still going to be the most needy.
And Dwan, I also remember there's a weird wrinkle about how Shriver is counted. And so those organizations, is it right that they back out the Shriver somehow? Bonnie just said Shriver doesn't count. So the Shriver, because those organizations many of them are Shriver programs, they report that data slightly differently.
Yeah, the Shriver data, as you all know, so a lot of our grantees receive Shriver money, and so it's a higher than 125 income threshold. So obviously we allow that. We just ask them to back out those qualified expenditures when it's between 125 and I believe Shriver's at the 200%. So that might cause a little bit of a wrinkle there, but okay. If there aren't any other questions, we'll move on to the next slide. Okay. Erica, do you want to?
Sure. So then the next question asked programs to indicate the strength of their preference regarding a possible change to the income eligibility threshold from 125% to 200% of the federal poverty level.
Mm-hmm.
And as you can see, there was pretty overwhelming support for making this change, which was would have been indicated to us previously, but as Dawn mentioned, we wanted to actually measure the strength of the support for this change. And so over 85% of respondents were either strongly in support or in support of the change. A very small amount were opposed, and most that were opposed, we followed up with them, and they had concerns about capacity issues, but most programs felt strongly about the fact that this is way too low, using 125% of the federal poverty level, and that 200% is an improvement. But if they don't make the change, there's going to be a whole population that's not getting services anywhere. They may not qualify for services elsewhere and not be able to afford a private attorney. So.
And just to underscore,
right?
I'm sorry?
I guess it's that, yes, I understand that it allows potentially more people to be served, but if your funding is stagnant, absent an increase in funding, you're just making choices among eligible people about who you can serve, right? And so the number of potentially eligible people goes up, but the dollars you have to serve them hasn't gone up. So I don't know that I think it, I don't know how that plays in like the real world of who you end up serving as a result, right? I mean, it's just, anyway.
No, that's a fair point. That's something that like we have talked to the community about and the webinar, and I know LAC has talked to them about, because yes, right now, at least with IOLTA being low, there's not increase in funding. I wouldn't say it's a dilution of funds, because we're not, and I don't think the community
I
would
didn't say that. I just viewed it
Yeah.
as the pie's the same size, but the IOLTA pie for next year is going to be what the IOLTA pie is. And now we're talking about how many people are going to be eligible, and programs are then going to choose within whatever resources they have, and other resources may go up or other resources may go down. I mean, we don't know that. We just know IOLTA resources are going down, that you're not going to have increased funding to serve the additional people that are eligible.
Yeah. Yeah. And that is a concern. The other thing I wanted to underscore from what Erica said is that we had a conversation we tried to have a conversation with the folks that voted opposed, strongly opposed, and the one that didn't respond, they responded to the survey but didn't respond to this question, and to really try to see whether how strong their opposition was, and whether, you know, we want to see if we take this to the legislature, we don't want to split in the community. It's going to be just not good for the community, not good for the state bar, not good for the commission. So we wanted to get a sense of where they are. And Chris, could you report on that? It was that the one opposed with affordable housing advocates, right?
That's correct. They're the ones whom state bar and LAC staff were able to reach, and said they understood the proposal and were against it. Whereas we suspect that the other two who were in opposition might have fallen in the group that was confused about whether or not it necessitated a change in the funding formula to do this.
But we didn't make contact with the other. I know you tried to reach out to them, but we couldn't make contact. But Chris did talk to Catherine at Affordable Housing Advocates, and Chris, let me know if I'm mischaracterizing this. But she said that, like, philosophically, she thinks she's opposed to it, but she's not so opposed to it that she would advocate otherwise with the legislature. And she just said that she just wanted a commitment from the state bar and LAC that at some point, we just keep the conversation going if there are going to be other statutory changes, or perhaps someday we will revisit this.
I've got a legal question that builds off of Catherine's observation, that if the statute's changed to 200% of the federal poverty level for qualifying or for being eligible clients, does that prevent a program, because of their own limited resources, prioritizing those clients who are at the 125% level?
No, I mean, every program establishes its own service priorities. I don't think that they would be limited in terms of being able to focus on the population at or below 125 just by making that change. In fact, most programs, the reason they cited for wanting to make the change was to have flexibility when you had compelling cases for clients who may be between 125 and 200%, not that they wanted to make a wholesale change to focus exclusively, say, on that population.
No, and there's, Jim, that's right. There's not a limiting factor. Like, if they wanted to still maintain the 125, it's an organizational decision, though I don't imagine they would if we're going to change up to 200. I imagine that most, if not all, will want to raise to give themselves that flexibility.
I mean, you almost have to do that. I mean, if you want to maximize your qualified expenditures, I think you would be foolish to not increase your eligibility to include 200%, because then you're limiting the amount of qualified expenditures you have based on the prior definition. So I would believe every program is going to raise it to 200%. And that's sort of like who in theory is eligible. And then each program establishes eligibility criteria for who they're going to serve in priorities. Often I think it's not based on like poverty level, but instead based on a particular set of issues that become the issues that they're going to provide representation on. So it could be, evictions, or it could be, access to, some sort of government benefit that's tied to other kinds of criteria. But in my experience, people aren't saying my priority is people that are at a particular level of poverty.
Exactly. And because resources are so limited, some programs go as far as to say, like, trying to categorize particularly vulnerable clients, limited English speaking, you know, and so forth. So it's layering on kind of those factors in. And it's not always solely income.
So just because I asked the question on the prior slide, so do we know, like, so we have these support centers included in this vote, right?
Mm-hmm.
And so do we know where the support centers are?
Let me take a quick skim and see if I can't distill that in like 10 seconds. If it takes me more time, then we might follow up.
I'll give you a minute or two.
Oh, that's so
I
nice.
think Selena had a comment, so maybe as Selena's commenting, Chris can.
I'll take that minute while Chris is doing math. To follow exactly what Catherine and Dwan said about prioritization, what we heard from folks on phone calls is that people may want to prioritize limited English proficiency, families with limited English proficiency, or they may have a strategic reason why they would want to beef up resources in a particular area, and would perhaps serving multiple clients within the same building if there was a particular landlord who was doing unlawful evictions. And so there were both strategic reasons around the substantive legal issue and also the vulnerable populations that Dwan said. And my very last point is that organizations that receive Older Americans Act funding are supposed to prioritize populations of seniors who are, I can't remember that there's like a certain term that they use. It's like of the highest need. And of the highest need, it's things like people who are bound to their home because of lack of transportation, people who are limited English proficient, or people who are at the lowest level of poverty. And I think a lot of programs do that kind of calculation already. And so I suspect that they will continue to do that calculation when the threshold rises.
Mm-hmm.
That's it.
You know, and then from our experience going on monitoring visits, because part of our monitoring visit, we ask for what is your policy on accepting clients? And, you know, the programs really across the board put a lot of thought, and like, they really have like, it's formalized the way they process it. So this is something that, you know, is not done lightly. And I'm sure you know that, Catherine, from your own organization, but it's something that they take really seriously, and it's multifactorial. So, and again, I don't think it's always just the income.
And in the slides here, do you go over when this would impact programs?
What do you mean when it would take effect?
Because Catherine had raised the point of, it seems like it's not the best time to increase the eligibility pool because IELTA has gone down. But at least my understanding, which if it's on a slide or you can correct it later, is I understand the timeline won't impact grants until 2024 grants, is my understanding.
Yeah. Well, I don't have a slide on that, but I guess we could talk through kind of the next steps, and if it went into effect. It's obviously going to depend on how if the legislature approves it, like when it takes but the thing is, like, how we do it now, we count qualified expenditures from the previous year. So I guess just talking out loud right now, say they approved it this year, it would be a little bit too late for the 2022 application, because we're already rolling out the 2022 application in a couple months. It would be, and then they're already collecting mid-year 2021. So it wouldn't be until they collect a full year, I would imagine, in 2022. So that would mean that it would be 2024 application. Yes, that is correct.
Why not 2023 application? We skipped over a year.
Because you're looking back, if you apply in 2023.
It's 2022 data?
It's 2022 data. So it is 2023.
No, you report your 2022 clients in May of 2023. When you close your 2022, you report that after the fact. You report a full year of closed clients later in the following year.
You report it, but I guess you could separate that from when you apply, as long as they have a mechanism to track. So maybe if the thing is, it depends on if the legislature is flexible in giving the state bar and the commission authority to figure out like when it would go into effect to cause the least amount of disruption to existing grantees. And that's what I would ask the legislature, to have us design it in a way that is like, but the thing is, yeah, I get what you're saying, Selena, in terms of that's when evaluations are, but that's not necessarily, you could have, because the thing is, like, our new grantees, they don't have to submit evaluations, but they have to have a mechanism to track what's above 125. So you could
like
disaggregate the two.
Do your budget, right? So when you report your qualified expenditures, whatever month that is in, that is the month in which you have to have your data for the prior calendar year to be able to make that, to say what's qualified, which is based on client eligibility. So that's why I think it's 2023. And I don't, I mean, we can get into, or you all can get into the, how would this become effective? I mean, I might make the push to try and have this put into some sort of trailer bill language, right? And have it be that, which would allow it to be effective, I suppose, earlier, right? As opposed to just a regular bill.
Well, it wasn't going to be a standalone policy bill. It was going to be an amendment to the state bar licensing fees bill.
Well, which goes into effect in January then?
Because Leora had agreed to carry this as an amendment when it goes to her house.
Okay, that makes sense.
Okay. So, and yeah, we can hash out the logistics. And I would encourage Selena to ask the legislature for flexibility in our design of it. So to buffer, enable it to go quickly, but we, think about when, so it's not a burden for a client if they need some time to start collecting the data and all that stuff and figuring out how to increase that. I think it's easy enough, but we want to give programs, I guess, maximum lead time to build it into their CMS and all that. Okay.
So I was able to pull out 14 of the 15 support center respondents. I'll find the 15th in a moment. But for this question, 2 support centers were neutral. 3 were neutral. 1 was strongly. Excuse me. Apologies. I was looking at the wrong column. 2 were neutral. 4 were strongly 5, 6 were strongly support, and then 1, 2, 3, 4, 5 were support.
Can you say that one more time, Chris?
Yeah, sorry, especially since I was looking at the wrong column. 2 responded neutral.
Okay.
This is how the order it displays on my spreadsheet. So I'll actually try and go in order of the bar graph from left to right. So starting with strongly support, it's 1, 2, 3, 4, 5, 6, 7 strongly support.
Okay.
1, 2, 3, 4 are support. 1, 2 are neutral. No support centers opposed.
Okay. Are there any other questions before we proceed? Okay. Okay, here, and I think we already talked about this, but these are the 3 programs that oppose increasing it to 200%. So again, we talked to, that seemed to be because we were able to make contact with them. We know the reason why they don't want to, but they have said that they won't, oppose us at the legislature, and we were not able to connect with UC Davis and Yuba.
Well, isn't the affordable housing, I mean, isn't their concern addressed by the issue that the changing the poverty level won't affect their prioritization? And they were worried that if you changed it, that they would have so many more clients that they had to serve that they couldn't do it, right? So it's really a moot objection.
Well, they had several other objections too. It seemed to me, at least, that they were just uncomfortable on several, but again, they said they're not so opposed that they would cause a barrier at the legislature. So I think that's a more important piece. And again, they just want us a continuing conversation.
They might have been a group. I mean, I would have maybe read that they wanted it increased tied to the housing index because, what is affordable depends on the county, and that sort of was off the table. That's how I would read it, but that is complete speculation on my part.
Yeah, I don't know. Did they say that about that they prefer AMI? That's why they're so against 200%. Chris, do you know if they said that?
They didn't say that to me, but I'm looking at their responses right now just to see if they put that in their responses. Okay.
Oh, is there a comment? Was there sorry, because I'm sharing, so I can't see if there's somebody else has a comment.
So for affordable housing advocates, just how they responded to the surveys, they opposed every proposal except keeping the distribution formula the way it is today. So they opposed raising it to the income eligibility threshold to 200% of FPL, and they opposed the AMI options as well. The basically any option to raise the income threshold.
So I am currently seeing somebody's messages and now their list of people, I think. I don't know.
Oh, I'm sorry.
No, I don't have your
Is
PowerPoint
this-
anymore there.
Okay.
I'm going to pull, I'm going to quickly review Affordable Housing Advocates' narrative comments to see if they
Yeah, it's fine. I really,
eliminate.
I mean, it doesn't, I don't think it's here or there. I mean, mostly the questions I'm asking are just from, in part, my work in the legislature for a long time about the questions I think you will be asked. And so it's as much just to sort out, like thinking through like the approach of like, you know, the approach of a change and what that should look like. So I think the data is really, like if you back out the qualified legal services support, which I think kind of have less to do with this topic, it's like a strongly support or support that's a little bit over 75%. So you just may want to know what that is in case you're asked those questions. I mean, the legislature, while many are supportive, there's always going to be questions about it. So anyway.
Okay. Okay, should we go on?
Yeah.
Okay. Oh, go ahead, Erica.
So in addition to asking about a change to the client income eligibility using a higher percentage of the federal poverty level, we also inquired about using area median income as a substitute measure instead of the federal poverty level. And we asked, this slide focuses on 50% AMI, and then we'll also look at 80% AMI, which some organizations had requested that we look at. And so we had talked about it during the webinar with grantees, and it just wasn't our recommendation to use AMI instead. It varies from county to county, and it seemed that sort of the most straightforward thing to do would be to use the federal poverty level, but we did ask for their opinion on these questions. And as you can see, most programs, the most popular response was neutral, that programs didn't really have an opinion on using AMI, didn't feel strongly about making a change using that measure, and that the programs that did have an opinion, they erred on the side of opposing using 50% AMI.
Do you have a sense or any sense of why that might be? That seems like a really high number for it to be, or at least a high percentage as neutral, but also a high percentage opposed. You know,
Mm-hmm.
it's very variable. So do you have any sense of what the source of that is?
Yeah. So from, and Dwan and Chris, you can jump in if you had a different sense, but when I was looking at the narrative responses, a lot of programs just didn't seem to focus as much on AMI. They tended to prefer the federal poverty level. I don't know if that's because of familiarity or, you know, the fact that it would subject different counties to different income measures. And if a program operates in multiple counties, that means they may be using different income thresholds depending on which county. That is speculation in terms of, you know, maybe administratively that would have been difficult or frustrating, but we didn't get a lot of narrative responses focusing on why organizations just didn't feel as strongly about AMI versus the federal poverty level.
Yeah, I think that a lot of the discussion really focused on moving to 200% because it seemed like though there was traction at AMI, that was more of a minority opinion. And it seemed like, and at least Selena communicating out to programs. If you want to make a move, there's more traction with 200%. And I suspect that's why this is all over the place. So maybe philosophically, some people really believe that AMI is the better option, but you know, they rather have some change than no change, even though it might not be, the 200% might be their optimal choice. Lena, is that accurate?
That's definitely accurate. A lot of folks had said, things like, other grants or other government benefits may be tied to AMI, and they were kind of questioning why we weren't increasing the threshold to a much higher level. But I think that it was Catherine Blakemore, you made a point at some meeting, I can't remember if it was Trust Fund Commission or somewhere else, that like this really should be tied to poverty funds. And so tying it to too high of an AMI gets it a little bit, it blurs the line between whether this is really meant to help people at the poverty level or helping people who are slightly below area median income. So I think a lot of organizations wish that they could serve people at higher income, but they at least seem to have very strong consensus around the 200%.
And I think my worry was sort of just the messaging and potential challenges to the underlying statute if it got too, like, it's just harder to make the case about the beneficiaries and why this is a good public policy if I think is that. Plus, I think administering something that's different in 58 counties as a director of a program that used to provide services in 58 counties would be quite challenging.
It is quite challenging, Catherine, and even like with our pro bono threshold, we give that flexibility, but it's confusion. We have to clarify when we go on monitoring visits and people aren't using the threshold, and it changes so much more from year to year. So
and my suspicions is if you did it, it would be more of a radical shift from rural to urban. Yeah. Although we couldn't run that analysis because we don't know how in each county the income's distribution below the median is distributed. But I think I just have that strong feeling it would really radically, just because of the numbers involved with the urban areas as opposed to the rural areas.
Yeah, we agree with you, Jim. And Jim and us and our RIA teams really tried to run some more analysis on the AMI, but because of how the data with the community census survey, it just we can't get at it. Okay. And then this question is the same question, but AMI at the 80%. So again, as you can see, more kind of the responses are distributed across the board. More neutral, some stronger opposition. So I don't think this one is even a viable option. Okay, and now we get to a changing. Would you support changing the IOTA funding formula based on a county population at or below 200% instead of 125%? So when we drafted this question, I thought it was crystal clear, but in our feedback from programs, it wasn't clear. And so this is part of the confusion. As you can see, now that I think about it, and it's been a couple weeks, I see why there was confusion around this question.
And this was designed to tease out the allocation among the counties, right? Which gets at the exactly. Question, which I feel very clear-headed about, given the discussion at the last trust fund meeting and kind of what was said today of people concerned about an impact on rural counties. So
yeah.
Anyway.
But if you can imagine, like, because it's technical, we had so much data that we kind of previewed to the commission too. We previewed to the community. It was really dense data, all those graphs. This piece of it, I think, just for a lot of programs, was hard for them. It was too conceptual and abstract. Erica, do you want to go through? So, I think the big takeaway is, though it seems like the responses are kind of spread out, there are a high percentage that's neutral, and I think they really just didn't have an opinion. I mean, I truly believe they didn't want to. It was like, again, conceptually they couldn't understand, but I think more importantly, if you add them, strongly support and neutral, it's yeah.
Well, I just think if you add the opposed, it's at 33%, which is quite different than the earlier slide where people were supportive of the change of client eligibility, right? So it's harder to say, I think, that there's a consensus here than there was on the earlier slide.
Oh, yes, that's what I meant to say. I'm sorry, I went the wrong direction, but yes, that's what I meant. What you just said, Catherine. If you add the opposed and the strongly opposed, that you clearly not consensus.
Yeah, and I think if I'm not mistaken, this was sort of the main question that Chris followed up with programs about, and that sort of the source of the confusion was the feeling that this had to be tied to client eligibility for some respondents. And so it wasn't necessarily a feeling of independently wanting to support this change to the funding formula, but feeling that if that was necessary to change client eligibility, that was the motivating factor more so than the funding formula itself. But based on actual feedback from programs, it wasn't, this is not representative of their actual sentiment regarding the funding formula alone.
Yeah. And that raises an interesting question to me. How does that argument go to the legislature where you're saying we want to change the eligibility level, but we don't want to change the funding formula?
Because we don't want to adversely impact rural counties, which are some of the poorest, but at the same time, we want to give programs increased flexibility about who they serve, given kind of, the difference between 125 and 200. That's what I would say.
Yeah, no, that's exactly. And I think we say almost verbatim to that in the memo, which is, I think that's the honest truth. And that's the hesitation. We don't want to move funding, existing funding now out of rural and high impoverished areas. But we want to give programs flexibility.
I would suggest then the data that I would show for that would be the spreadsheet data and not the graphs that were presented, because the graphs were, I think, a little confusing.
Yeah.
And didn't make the point that well.
Yeah, and I think what, we'll need to strategize with Selena in terms of actual next steps, what she's going to be presenting to the legislature and what we can help her gather to make it as clear and as easy to digest. Because the learning experience that we had with the survey and the webinar was sometimes too much data. I don't know how, we wanted to give the community everything so they can make an informed decision, but perhaps it was too much data.
Dawn, Will Bocelli has a comment.
Yes.
So it says, if the chair would allow, would this mean that programs would need to track 125% and 200% of federal poverty level recipients for purposes of determining client eligibility at the proposed 200% and calculating the qualified expenditures used to determine the funding formula allocation?
If I'm understanding that question right, tracking both 125 and 200%, no. If it changed from client eligibility to 200%, we don't change the funding formula. We just need a mechanism from programs that they're tracking expenditure when they're serving clients above 200%, those expenditures, so that they can deduct it when they apply for our funding. So it wouldn't be to track both 125 and 200. It would be a mechanism to track 200% of clients above 200%.
And Will, you've been unmuted in the event that you have a follow-up question to that.
Sure, thank you very much. So the services that they provide to under 200, to the 200 FPL new level, they would count towards qualified expenditures in the future?
Yes, that's correct.
And would that impact the funding allocation? I thought that was used to help calculate that. I was just curious.
So yes, that we take the amount of money that they spend on qualifying clients. So before it's up to 125, now it's up to 200%. So anybody that they serve between those additional clients between the 125 and 200%, they would count that as qualified expenditures. It's hard to predict how their allocation would change, because it kind of depends on the other programs within that particular county, how theirs would change, because it's based on, it's a pro rata share within the county.
Yeah, so I think that actually raises a interesting point, because I think we've been sort of discussing these objectors, nothing will change for them, but it will, or it could, if other people in their county, other providers in their county do take advantage of this and they don't.
No, we
because
made
the-
that 100% clear to them, and
Yeah,
that's why we
okay.
wanted to have the webinar, because it's not just like the implications across funding California. We wanted them to know that it could have an impact on their particular allocation, and that's the point that we stress. And I hope we stressed it well, Jim. And I mean, you're on that webinar several times.
No,
and
okay, I was just, it seemed like there were a few comments earlier in this discussion amongst us that suggested that that wasn't the case. So I think Will's question makes a good reminder of that.
I guess I heard, I mean, I know from the prior discussion, there was concern among some commission members that would this result in fewer services to individuals who are at 125%. And so I actually think the answer to the question, if that's a concern, is you could require programs to track data on who's 125% and then who's between 126 and 200% if you wanted to see if there were any sort of how, you know, who was being prioritized and who wasn't, if the bar wanted to do that. I don't think there's anything that necessarily would prohibit the bar from asking that kind of data question.
Yeah.
And I don't know whether it's a good idea or not. I haven't really thought through the burden on it's, you know, it's whoever's doing the initial eligibility screening as to which box they check, and keeping track of two different poverty level tables really is what would be involved. But I know that a couple of people, at least on the last call, indicated some concern about people who they thought were more vulnerable would get fewer services.
Yeah. I mean, yeah, there's not anything to stop us from asking, but we might want to think about that to see how fruitful it is. I mean, it would be easier for larger programs because their CMS system is built out and it's pretty sophisticated, and they have to track different eligibility for different funders, so they're not unaccustomed to that. With the small programs, I mean, it might be a hardship. So
I don't know. Yeah, I don't know I don't know the answer to who does it impact more, right? I mean,
Well, I guess it had to be program by program how they set their priorities, but the number of persons eligible will definitely increase even though the money doesn't.
that's true.
Yeah. Yeah.
And just to be clear, so is my understanding when we said it didn't affect the funding formula, what we say it's not affecting using the 125% of the poverty level to distribute resources across counties.
Correct.
But it does affect the funding formula insofar as qualified expenditures go.
Yes, that's correct. Yes.
And we don't understand. I mean, that was a question I think I asked at the last meeting, and it seems like there isn't any real way to get data about what that impact would be, because you know, if you take LA County that has whatever number of programs, but a fairly large number of them, it's going to depend on what each program does and how many people they count as being eligible and the amount of qualified expenditures it took to serve them. So if you decided to serve people with 200%, but decided you were going to provide them with short-term assistance, the impact will be less because the amount, you know, you're not spending a lot of money to provide short-term assistance. If you're deciding to change your program and provide significant representation to people at the 200% of poverty level in a systemic piece of litigation, that might more significantly boost your qualified expenditures. There's just like, there's a lot of variables, I think.
Yeah. And you know, we did get questions from programs that reach out individuals to us to see like what like the impact was. And, you know, we try to run through the analysis and look at the county and see but what we said on the webinar is that if you're already at 100% qualified expenditures, it might have more of an impact for you, because if there are programs within your county that are not at 100% that can now serve more qualifying clients, then their qualified expenditures are probably going to go up. Whereas yours, you're already at 100%. Even if you serve different, your spread is different, you serve more, you're at 100%. Your allocation. So it kind of depends on your neighbor. And so we did implore those programs that are 100 to really think through, because it might have a dollar impact, and if they're comfortable with that. And that's the point, Catherine, I know you made it at the last commission meeting, that we tried to really emphasize. And then I know Selena reached out and talked to senior programs, because a lot of senior programs are 100, if not very close to it, and they're small. And so the dollar impact might be greater for, like, you know, they might feel it more if it went down. And so we were we were mindful of that. But it seemed like people understood that risk, but still voted in support. Selena, I don't know, can you share if you have any other insights?
A couple of small programs said that they were a little bit worried specifically about the impact to their own grants. And so I created this kind of cheat sheet of, I can't remember, it was like maybe 10 to 12 different reasons why an individual grant would change. Because I think a lot of organizations, they just worry that any threat to their funding is the biggest threat. And I listed all the reasons why their individual grant size would change on any given year, either up or down, showing that this is one of the many factors. But after talking with a lot of folks, they said that they understand that this is really a, the specific changing it to 200% for eligibility is a long-term view. And so they supported it. But I think a lot of organizations were just really kind of worried about their own grant size because IALTA had gone down.
In theory, wouldn't the programs that are hurt would be small programs who are currently at 100%, who are in a county that has a big LSC program where a third of their clients are above 125%. Now all of a sudden, but below 200. So now all of a sudden those 25% extra clients are going to be in their qualified expenditures. I mean, that's the worst case scenario, right?
Worst case scenario, but I don't think that there are any LSC funded programs that have that low of QEs. I think that most of the large programs have very, very high percentage QEs. And I actually spoke with a couple of executive directors who had that concern from the larger programs to say, they said, I'm worried about the smaller programs in my county. What will it impact if our QEs increase? And I said, well, that's a very right question, because I know you actually have a number of pass-through dollars and subcontract with these other organizations. And so you can make determinations about who counts what clients. If you're worried about the impact of those other organizations, let them count all the clients that are pass-through funds. Because I think that's the case of it. Most of us, I don't know, I can't say most, but a lot of the smaller organizations have subcontracts from the larger organizations in their county.
I mean, my instinct, honestly, with this is to tie, now to ask this. So like, let's say there's a motion to support this change, which seems to be what programs are saying, support the change for the client eligibility, but not for the county allocation. So that's sort of how I'm reading these slides so far. But to ask that be accompanied with an increase in funding for legal aid programs, because that's the way you balance out any kind of differences in some ways. And that may or may not happen. It just seems like a way to say, look, there may be an impact on some smaller programs in a county. And one way to mitigate that would to be at the same time request an increase in state funding, equal access funding or something else. So, and the state's going to decide what it's going to do, but I think that's a way to mitigate it.
Yeah, and Selena, I mean, that piece we probably defer to you on how strategy-wise you want to present it. And again, this is all theoretical. It might not be, because we don't have the QE numbers at our fingertips. Okay. Let me move on. Okay. So, this question is the second question related to funding formula, and it was to what extent would you support not changing the IALTA funding formula, even if we change the income threshold? So this is why I was going to say before I jumped the gun a little bit, that I think what's important here is that if you add the 21%, 35%, and 38%, it's strong in people that either show support or are neutral, so that we know that there's not going to be strong opposition at the legislature regarding this.
Regarding the second piece of this, right?
Yeah, just the funding formula.
Sorry, just like making sure I'm.
And Chris, Erica, I don't know if you have any insights about the people that strongly oppose this one organization that opposed and the 3 that strongly oppose.
I actually did talk to them. Let me go back and look at my notes. Just give me 30 seconds. I want to make sure I state it correctly. All right. Correction. I spoke to several organizations that expressed great confusion about this question. I did not connect with the 4 Disability Rights Legal Center East Bay Community Law Center, Inland Empire Latino Lawyer Association, and Legal Aid Society of San Bernardino that were opposed. In fact, they make up the one opposed and the 3 strongly opposed. In fact, I sort of suspect that they might have shifted to neutral had they had a chance to react to LAC's clarified position. LAC sent out this really helpful clarification of its position on this question over the weekend. And I have a suspicion that one or more of those 4 might have shifted. The folks I did talk to who expressed uncertainty to me about this question, but voted neutral, tended to say, and maybe like 3 or 4, I spoke with maybe a dozen orgs, and maybe 3 or 4 of them said this. They said, you know, this one really confused us. We'd love more data and time to think about this one. There's a part of my intuition that says if we increase the eligibility threshold, the formula should shift to match it. That generally funding should be tied to where the clients live. The way the funding gets distributed should be tied to where it lives. But every single one of them said, I am happy also with the existing formula, happy to support it, and wouldn't want to rush the decision to like change this overnight. So all of them said, love to have more time to think about it, but wouldn't push the state bar to change this at this point in time.
And Selena, do you have anything to add about this? Because I know this was the piece that, like I said, when the survey results came in on last Wednesday, was a little bit more all over the place. And I think now, at least on the staff perspective, we're more comfortable with this response if we were to move forward with pursuing the change for the client eligibility, but leaving funding formula status quo.
Yeah, I mean, this is the one that LAC helped lead to the confusion, because I initially thought, although Dwan corrected me, I initially thought that we had to do both. And so a lot of organizations said, I don't love the idea of changing the formula or the county distribution, as Catherine has shorthanded it. I don't love the idea of changing it, but if we have to do that to get 200%, I will support it. And so, in the middle of that, Dwan clarified that we didn't have to do both, but because I didn't have a clear recommendation to the community, that has led to the confusion. But I think, at least from all my conversations, this was one that, people are worried about the rural funding. People do not, even the urban counties do not want to take from rural counties. And so if we can leave the formula county distribution alone, I think organizations would strongly, strongly be in support.
And that's why I think, like, now that we see the confusion, talking about it in terms of county allocation, even if it's just in parentheses, would also help the legislature understand why it's not. I mean, members don't actually like to see money move away from their district, right? So their counties. So I just think calling it county allocation will be helpful to lots of people.
Yeah, I think now that I hear you saying it, it gives it really a distinguishing factor that it's confusing otherwise.
Well, I didn't think about it until we got into all of this, and you can see the confusion. And
no, I mean, this whole process has taught us a lot too, in terms of like surveying and like, we really did think we were gonna get a higher response rate, but then once we sent out, we're like, we don't get that type of response rate for anything. So why would we have thought that? Yeah. So this is, in retrospect, the 80% is really high. But it's dense. This part of it, for a lot of programs, and in our effort to try to be transparent and provide all the information, I think got lost when we were doing the webinar. So we could have pared that down a lot more.
It's confusing anyway when you have not changing and then you're saying not. I don't know. The response is the not. It's kind of a hard one to follow, I think.
And this survey, we did beta testing on the 3 of you, as well as like we selected like 5 or 7 programs, which all had amazing things. So we did the heavy edits, and it's still, and surveying is hard.
Yep.
Okay. So again, we already went through this, but these are the and I think Jim had asked this in an email for us to run to see how many were LSC versus non-LSC. So all the ones that voted opposed to it, Jim, were non-LSC, and they're all QSPs. And again, just high level summary of what our big takeaway is. So for the income eligibility question, so the two issues, right? First on income eligibility. To us, there seems to be overwhelming support to the 200%, even though it's not unanimous. Sorry. And then on the funding formula piece, based on the responses, though not quite as high as the client eligibility, more than half did support a no change. But I think the second piece is important in that if you add up the supporting no change with the neutral, it's 94%, and then we don't anticipate opposition. So really, when we set out to see whether there was any traction, it really was the client eligibility. So we're hoping, even though the funding formula response isn't as strong as the client eligibility, at least we can move forward with the change, given the response rate. I think that is the last. Oh, I'll let Erica summarize the narrative responses, since I don't know. I know we sent that out late because people are still revising that. So we did review that, and I apologize if you didn't have a chance to review all the narrative responses that we compiled, but Erica can give you a high-level summary.
Sure. So yeah, we read through the narrative responses and tried to pull out some of the major themes in what grantees were reflecting on when responding to the survey. And so we had several responses that highlighted the fact that 125% of the federal poverty level is not an accurate measure of poverty or hardship in the state of California, and that it's too low. There are a number of people living in poverty in California that can't get services that might be above 125%, and so they expressed the desire to have that flexibility, as we mentioned before, for compelling cases. As I mentioned before, I think that those who had some hesitation, they were expressing concern about capacity issues, which we've discussed, but I don't think most programs, on the flip side, there are already capacity issues, and so allowing programs some discretion isn't going to take away from the fact that they are still going to be serving individuals who are in need. And they also highlighted the administrative efficiency for programs that already have other grants that allow them to go up to 200% of the federal poverty level, that this would just make things more uniform for them and cut down on the back end and allow them to focus more on service delivery. So as we just discussed, there was some uncertainty among programs about how they individually would be affected. And unfortunately, during the webinar, when we spoke with folks individually, we couldn't give them that answer. We don't have that data at this point, but it is safe to say that some programs will be affected and have some change to their funding or some reduction to their funding. But even in light of that, or in face of that, a lot of programs expressly said that they wanted to support a change that's best for the legal services community as a whole. So even if their individual program loses some funding, they went into that knowingly, they understand that, and they still want to support this change.
Sure.
So that was encouraging to see. And then as far as the funding formula, not too many of the responses focused on that. Most of the narrative comments were about the income eligibility threshold, but for the funding formula, the main concerns, as we've discussed today, we're making sure that rural communities and counties that are already impoverished are maintaining a stable funding source through IALTA and EAF. So for the programs that understood that they didn't need to be tied together, that's why they were in favor of not changing the county allocations.
I didn't have a chance to go read through all of those, the written comments, but did anybody discuss the problematic assumptions behind the origins of the federal poverty level? I mean, my understanding it was created in the early to mid 60s by Molly Orshansky, an economist for Social Security, for the war on poverty for the Johnson administration. The assumption was that a third of poor people's budget is spent on food. And therefore they calculated what that cost back in the 60s, and they've just been updating it since then. And my guess is in California, your average poor person does not spend a third of their budget on food, given the high cost of housing. But I was just wondering.
No, I don't recall seeing any comments about that specifically.
Yeah, I don't remember seeing that either, Jim.
I mean, I heard a lot of things in our meetings about this just being a holdover. I think folks are saying from the 70s, but clearly it's older than that. That the poverty threshold itself is problemsome because it makes assumptions that aren't true about California.
Yeah, well, especially the third of your budget on food, that just doesn't seem reasonable in California at all. But
yeah,
oh well.
But I think another, other formulas have been adjusted, like eligibility for Medi-Cal for some people, or the Affordable Care Act is much higher than 125%. Medi-Cal, I think, for children goes up to like 300% roughly. So, just aligning things better with other measures of poverty makes sense, I think. And I think as long as it can be framed as a poverty standard and not something that's going to move away from poverty, which I think causes a host of other problems, I think it's fine. I guess, do we know any additional people are eligible, the difference between 125% and 200% in California?
Yeah, we ran that number. We shared it with the commission.
Yeah, I think it's the population at 125. I think it's about 7.5 million right now. And if we went up to 200, it'd be 12.1 something.
Yeah, that's what it was. It was about a 5 million. Yeah, it was about a 5 million more people. You could use IOLTA funding to serve, not necessarily obviously that we serve, but if they want to, they would be eligible to count that as qualified expenditures.
Yeah, my increase, my numbers showed it was about a 71% increase in number of eligible clients.
From a procedural, or assuming we get to the point where we're taking this is going up to the legislature, do we have a sense, and the answer may be no, not yet, but do we have a sense of whether, especially in light of some of the other priorities that they're dealing with right now, that there may be an effort to like take this and run with it, and use as sort of a springboard to do something even more based on whatever the political, kind of how the political winds are blowing?
We're hoping to keep it very narrow, Amin, and that's why, we don't want other parts revisited without doing a deeper analysis, because as you can see, even this piece that we thought forever had been talked about increasing, and there needs to be deep analysis because it has such an impact and a domino effect. So we don't want them to visit other parts,
right?
And that's why I think Selena is trying to have it attached to the fee bill, because we've been told that's it won't open it up, the sausage making of
yeah, that's why I asked, because I know that from our perspective that's what we want to make sure, but I'm just wondering if we have any sense of what the temperature is along those lines.
Is there any risk, I guess, to if we do it the way that you're suggesting in terms of attaching it to the state bar fee bill?
I mean, if it's not a controversial amendment, then the state bar will accept it as a friendly amendment to their bill, so to speak. And then the legal aid community will work to support, give messages. If any legislator asks a question about the impact to their constituents, we can answer those questions with the folks in their district who provide services. But if it's not a controversial amendment, then the Assembly Judiciary Committee staff have already agreed to move it forward. And if it's anything where it looks like it's going to be at risk of opening up the statute more broadly, then we can easily just say not this year and take away that amendment. It's because it would be a committee amendment, there's a little bit more control on their end.
Yeah. So I guess maybe that's a good segue into talking about next steps before we vote, and if you want to have more discussion. So if you choose to support a change today of moving it to 200% eligibility, but not changing funding formula, what will happen then is the Board of Trustees meets later this month on the 21st and 22nd of January. And they bulk approve it, meaning that at the beginning, the first meeting of every year, the Board of Trustees has to approve the State Bar's legislative priorities. We're already geared up to be an item. I've already, Erica and Andrea and I have already worked up the language to be included because it's such a short time frame that, and it's a chart. It's not a fleshed out memo. It's just part of a spreadsheet that they present to the Board of Trustees of all their legislative priorities. It goes first to, they have liaisons for the legislative priorities. So 2 board members work with a staff, State Bar executive staff. They've already been previewed that and so forth. And so we don't anticipate opposition, but it will go first to the board liaisons, board legislative priorities liaisons. And then if they approve it, it goes to the Board of Trustees to be approved. From my experience working with liaisons of the board, they've already, again, have been a heads up from State Bar executive staff. Donna already knows about what's happening, has given us her sign of approval. And so we don't anticipate opposition. There may be questions, but we don't anticipate opposition. So if that all goes smoothly and the board passes and approves that, we will then obviously let Selena know and then work in collaboration with Selena. Selena is going to be the one that will make the official ask to the legislature. The State Bar will be the support, and perhaps, and we need to work out strategically, perhaps it will be in the form of a letter that goes out maybe from Donna, and maybe Bonachet as the chair of the commission. I'm just thinking out loud, some form, something to give to Selena with this package analysis, and then Selena will make the ask. And I think Selena said she's going to do some additional analysis on perhaps impact on what did you say, Selena? Racial.
Like some race equity concerns because of households that may have one primary worker who has a couple of jobs. Are basically those minimum wage jobs where you piecemeal and they are ineligible for services now. We're going to dig into the ACS data, which is mine and Jim's favorite, to get a sense of who is impacted and who we would be able to serve and what that additional 5 million people look like, perhaps. So we're gonna dig into that before it's proposed.
Yeah, but Selena will be taking the charge in that piece.
Yeah, I guess. So do we think there's any, like, this idea of saying this should be combined with an increase? So given the low IALTA rates, that it should be combined with an increase. So I mean, I support doing this. I just feel like that you're really, you run the risk of dividing up a pie differently. And the counterbalance to that is more funding for legal aid, which legal aid always needs anyway. So what where would Leora be on that question? Or more importantly, her members?
Leora would support an increase because she has said over time, and I even remember when we had the Legal Services Trust Fund Commission working group that met in Sacramento in the Capitol, Leora said that she, if we ever changed eligibility, she would want to partner that with increased funding. In recent history, we've had increases to Equal Access Fund, which is what they can increase. We've had increases to that, I think, every year since 2016. I actually emailed Mike Harold, who's our now budget expert, earlier today to set up a time to talk to figure out what would be an appropriate ask. LAC would like to make an ask for an increased funding, but we don't know whether we would want to do that for this year or next year. So I want to get a sense of the politics. I also texted Kurt to say I'm going to still stay in contact with you.
Yeah, let's hope he's doing okay.
He texted me back, so
that was good news. And I guess so. This is the information being put forward now to the state bars for their legislative platforms. So is it helpful or not to include something in that about increased funding for legal aid?
I think currently, I believe, and Dwan may know if you have the work plan in front of you, I believe it's currently a state bar priority within the work plan under objective, like whatever, 1.1C or 9.1C to support increased ask for legal aid funding.
Yeah, I think generally it's part of the like the strat plan, and it's definitely part of the legal services trust fund work plan. I don't know if you all recall the last one that you voted on. That there's always a standing item to work to increase it. To add it to the actually the legislative priorities might be a little bit stickier because because it's part of there might be other politics that I'm not privy to because it is tied to the fee bill.
Yeah, I guess I wasn't necessarily trying to tie it to the fee bill. I think they would be done separately because one's really a budget ask and the other I now appreciate is a fee bill ask. I always just want to encourage the state bar itself as an entity to support increase in a proactive, not as a a goal out there, but in a concrete action way of increasing funding for legal aid. So I wasn't trying to tie it like you had.
Oh, I see what you're saying. I'm not always as familiar with all the politics of the ask. And so, I think I would need to defer to Andrea and Donna, who's not here, and probably more Donna to see her thoughts on that. So I don't know how likely that would be to now modify what we put in the legislative priorities to include that.
It's a good question. I would also like to raise that with Donna. Yeah, but it's a good question. Let me follow up on that because I think she'll have more of a strategic sense of that bigger picture. But I'll ask.
And the Board of Trustees is discussing their 2021 legislative priorities next Friday, the 22nd. And that's at the publicly noticed Board of Trustees meeting.
Yeah. And what I've been told is that we are not doing like a presentation. It's just part of their, and I will have to clarify with Donna, because usually with like our agenda items, they do have they take an interest in the trust fund commission, and they love, hearing about all the legal aid and stuff like that. So we do sometimes a presentation. I've been told we're not doing a presentation for that. That DAG, who's the main staff on that, is presenting it, and we'll be on hand to provide answer questions. And Selena, obviously, if you want to come and make public comments, that would be helpful. But I don't think we're making a fleshed out presentation like we do with IALTA funding or anything like that.
Yeah, that's my understanding as well. But I've teed it up for Dag, and he knows kind of every step we've taken in this process. So if he does have to turn it around quickly, he's not coming into it blind and knows this context on what the process has been.
Mm-hmm. And again, we don't anticipate opposition because executive staff has been kept up to date about the progress pretty much at every step of the way.
So is it, I guess, just to be a bit more concrete, so like if we said, for example, I understand there's a staff recommendation, which are the two components, right? So if we said support the staff recommendation and as appropriate, support increased legislative funding for legal aid, does that cause people great problems? I just want some way to kind of elevate the fact that we're increasing the potentially eligible client population by 5 million people, but we're not tying that to increased funding. And I think it's a legitimate sort of like issue to raise, not to oppose what the recommendations are, because I think they're the right recommendations, but just to say they're like kind of in any business, if you increase customers, you have to have a way to, be able to provide services to them, essentially.
And I guess my response, I don't disagree with you, Catherine, philosophically, but the thing is, like, I personally, because I'm just thinking about it now. I'm just like the implications of it. So I don't know if we want to right now tuck it in. It feels like we wouldn't have an opportunity to give thought in terms of, I know there's also the homelessness prevention, if that's getting removed. There's some other moving pieces for funding that I don't know. I'm just thinking out loud now. I'm not quite sure if I feel comfortable, though I agree, like, philosophically.
Yeah, philosophically, I agree. I don't know if there's a viable way to raise that in the context if this moves forward as a recommendation for this Board of Trustees meeting, given the procedural way it's all happening. But it's
but then what would be the right way to raise that, I guess? Because I actually, I mean, you can tell I'm getting a little passionate about like 5 million more people and a smaller pie of money. Like, I don't know, that's kind of a heavy ask on programs to figure out how to prioritize 5 million other people into it.
So
Well,
procedurally, I could speak a little bit to that. Like when this first surfaced at that October Rules Committee meeting, we notified executive staff, and then like on down then executive staff gave, who needed to know at the Board of Trustees kind of a preview. This is coming down. So I guess my hesitation is like that process hasn't happened. So if we tuck that in and we haven't done that, then they might not support the other recommendation, would be my hesitation, because there is just a lot of process at the state bar in terms
Yeah,
of
that's why I was trying to provide the wiggle room to say if appropriate, or like when appropriate, some words that say sort of like to give them the flexibility to say, like, I don't know, something, we're not going to do that now because whatever with the process. But it seems like such an opportunity to raise the fact that it would have been quite different if we were still in the environment that IOLTA was going up significantly. Then that's sort of the time that it almost makes more sense for it to happen. But anyway, we're not, so that's fine. It's just like, kind of, if not now, when do we say we want the bar to support legal aid funding then? So
another thought, and again, I'm just thinking out loud, unless Andrea, unless you're about to say something, go ahead, you say it first.
Well, your comment will probably be more substantive, because I was going to say first, you'll have to forgive my newness to this process when you ask if not now, when, how these things move through. It'll be my first time if this moves forward, working with the board, and then something going up to the legislature. So, the reason I said I'm happy to touch base with Donna is I just don't know all the nuance of some of those processes and strategy. But my other thinking just in terms of this upcoming meeting is, if there was a way to say along with this change, we ask that, the bar do more to support legal services, which of course we always would advocate for in this office. I don't know what the mechanism we would be asking for is, right? It's not tied to a specific pot of money, or how would they, increasing IOLTA revenue. So
no, it's really, my instinct was to say it's an ask to increase legal aid funding through the Equal Access Fund, which is tied to the same formula drives both of them. So you're changing both formula. You're changing the formula, which it changes.
Right. Sure.
Money, right?
Sure.
This is Brady. Sorry.
Oh, go ahead, Brady.
I just had one thought. Usually when these kinds of issues come up, I err on the side of, make your request, people will do with it as they will. But in this case, I'm thinking back, and I don't have the exact language in front of me, but when this subcommittee was formed, it was tasked with a specific task, and this arguably goes beyond it. So I'm just curious if, thinking about when the right time to raise this would it be better coming from the whole commission rather than this subcommittee?
Well, then it's, I don't know, when is the next commission meeting? It's
February 26th. I guess I didn't think of it in that context, because this subcommittee was tasked with deciding whether we want to support a statutory change. The funding piece isn't a statutory change, is that what I'm hearing, Brady? So it would be beyond the authority of the subcommittee to make that recommendation to the board. It would have to come from the commission. Is that what I'm hearing, Brady?
Well, this has come up in other contexts, and my answer is sometimes it's coming up in the paraprofessional. What recommendations are we allowed to make? It's like, well, you can make a recommendation. It might not be accepted because X reason. You're not speaking for the whole commission on this issue. And given that, and all the other concerns, it might be a reason, another factor to consider in holding back to another time.
But we were to make recommendations about the change in the formula. So I would just say fine. And as a piece of that, we also recommend that there be increased funding to legal aid. I don't know that, it can't be that we were limited to the draft recommendation of the staff at the time, and our only task was to say yay or nay to that, because that wouldn't particularly make sense, I don't think.
So what I was going to say before Andrea was that, we were really, Selena and I were truly trying to coordinate efforts for the January Board of Trustees meeting, because then it's clearly in the we'll make it for the spring fee bill. But when Selena and I, the March meeting we have thought would be pushing it, though that wouldn't make it completely unviable. So what we could do as an option is move forward with this, since it seems like we have some type of agreement. Have Selena maybe think about the implications, talk to executive staff, maybe bring it back to the February board of commission meeting, and then we can still tuck it in to the board of trustees if we want to move forward in March. Because they said what they've told us, the executive staff, is like January is not the only time they'll include legislative priorities. That's when they normally do, but they can do one-offs.
And a budget request, which would happen, has a little bit more flexibility, because usually there's a lot of budget hearings in March, and then there's a decision made after very, very quickly after the governors may revise. And so if the Legal Services Trust Fund Commission urged the State Bar Board of Trustees to prioritize asking for more funding for legal aid through the Equal Access Fund in the current budget cycle, there would still be time for them to do some advocacy, but practically speaking, what it would probably be is that the legal aid community would have an ask, and that the State Bar would support that ask in terms of timing, because we would already tee up an ask before the State Bar's March.
Oh, okay. So are you saying that that timing doesn't work then? We wouldn't. It would have to be approved.
The budget process is always strange, and it's even stranger now. I think it would be ideal if the State Bar earlier expressed a desire to support a budget ask. But in terms of the ripeness, it's not necessarily a ripe ask right now, because we're still figuring out our ask. But I hate to be a little wishy-washy, but I am a little wishy-washy on this, because I don't think we've clarified what our ask would be, other than, as Catherine says, we need more funding to support not only an increase to 200%, but the millions more people who've lost their jobs in the past year. And we're trying to figure out, LAC is trying to figure out whether it's a one-time request as a COVID response, or whether it's an ongoing request for Equal Access Fund increase. And in the current budget climate, what would be more likely to get our foot in the door?
Mm-hmm.
The same thing that's gotten your foot in the door every time, and the next year you say we still need to continue it. So I think it's tie it to COVID or whatever else is happening, and then increase joblessness, and then say that need is still continuing, the economy is still bad, whatever, right? So then I guess, so what I hear is people aren't thinking it's the best idea to tie it to this. So then how do we make sure that it's on the agenda for the February meeting, where maybe Selena can provide some information about what the legal aid ask is at that point?
You mean the February commission meeting?
Yeah.
Yeah, we can just work with Monashe. I mean, Andrea and I work closely with Monashe on that agenda. So yeah, we putting on the commission agenda is no problem. We just need to figure out between now and then and coordinate what, like Selena saying, what the ask is to make it, our best chance, right? Because Selena, if we need a kind of a lead from you, because you have to kind of figure that out, and then we see whether we support that or not. But we don't want to be of a split opinion, right? If we make an ask for EF and Selena's making an ask for something else.
No. I mean, clearly, like we want to be in sync about what the ask. We don't need different voices having different things. I'm certain the Access Commission would also support whatever the ask.
Yeah.
I think if it's tied to jobs issues, I think the chamber would be supportive of an increase to equal access, as they always have been. I don't think there's a reason not to do it this year, but I'm fine following a process that allows like a little more thought about what the ask is and how that plays out. So anyway.
So if you're agreeable, everyone, and maybe we do kind of put our heads in and work towards talking about it more in depth in the February commission meeting, and then we could still, if you don't think the timing, Selena, the March meeting for the Board of Trustees.
I mean, it's late. I will just say it's late, but there'll still be a hearing where they can weigh in, because really the work should be done really soon to get the ask into the budget. The governor's budget already is out, right? And so legal aid should be figuring out what its ask is now, and sort of, I'm sure Selena already knows that. I'm not trying to pressure her to figure it out. She already knows that. And it should be work that's done at those initial budget hearings that will be, I don't know, January, February, that kind of time frame, in addition to what happens after May revise.
And the thing is, Selena cannot move independently of us, though I think with state bar support, but maybe just procedurally, then the state bar once that, you know, we can come in and support, but so LAC doesn't need to, like, yeah.
No, that isn't, dependent on the state bar. I just think it's helpful to have the trust fund commission that's making a decision to expand the eligible population also say that that should be increased with increased funding, and that it would be fabulous if the bar supported that.
Is that also something that the commission could support independently as well, without going necessarily to the Board of Trustees?
No, because
I don't believe that's possible.
No, yeah, the commission is a sub-entity of you know, the state bar and the board, and that's why the board has centralized that in coordinating those efforts of what the state bar legislative priorities are, and the commission is part of that. So no, you wouldn't be able to do it.
For some reason, I seem to remember in past years, the commission sending a letter of support in something in connection with it, but I may be thinking about a different context.
Yeah, it all got streamlined more in more recent years. So your memory is probably not incorrect. We probably have done something from just the commission and didn't have elevated to the Board of Trustees, but that's all been centralized now.
Appendix I review and those meetings that were held about it, that's when I think that was sort of the change a couple of years ago now, I think.
I guess speaking also of Access Commission, at some point, we would love to, if this moves forward, coordinate with the Access Commission to see whether there's some traction, you know, to do the, you know, support. But I think that can do offline from this.
I will just say that the Access Commission has always supported an increase in legal aid funding and written a letter and so forth. So, and that anyway.
Okay. So
I don't think that's a problem.
Should we move?
I'll make a motion to support the two staff recommendations with the change from 125% to 200% of the federal poverty level for client eligibility, and no change to the county allocation eligibility.
Second.
It is. Right. Who second that motion?
I'll second.
Amin. Okay, right. Let me give me a second to pull up my roll call sheet. Okay, let me do roll call. Amin?
Yes.
Catherine?
Yes.
Jim?
Yes.
Great, motion passes. Great, a minute till. So then I guess next steps then in terms of the funding piece. Let's coordinate, and Catherine, maybe we'll set up a call too with you to pick your brain with Selena, and then Andrea can coordinate with executive staff in terms of procedurally, and then we'll put our brains back.
Thank you for indulging me in that little diversion from.
No. I think we do all, like, I don't want to speak for behalf of the group, but I think we philosophically we probably all agree with it. It's just to figure out how to best do it in this cycle or whatever cycle it is. But yeah. Oh, you froze.
Great environment, right? Like, we have to be thoughtful wherever we can be strategic about funding.
Okay, great. Well, thank you everyone for you know, such a thoughtful conversation, and we're so pleased to be able to move this forward. I think it'll be a really great service to the community that we're finally
answering all the questions, and
of course,
and Chris's quick research. That was really
thank you. And again, we apologize to not get you the raw data and all the more deeper analysis in advance. Hopefully next time, if we ever do this the next time, we can build in more lead time.
Maybe just not in December. How about that?
Oh yeah, not in December, exactly. Okay.
Yeah, right. Thanks for all the work that you guys did, especially over the holidays.
Everyone.
Take care, everybody.
Have a nice evening.
Bye.